All right, welcome. Today we are diving deep into a topic that can absolutely make or break you in the Queensland Bar exams, implied waiver of legal professional privilege. Seriously, getting this wrong in practice can have massive consequences. So let's get you prepared and break down exactly what you need to know.
So, picture this. You're in the middle of a case, and this lands on your desk. It's a classic exam question, and trust me, it happens all the time in the real world. So what's the move? By the end of this, you're going to have a rock-solid framework to tackle this exact problem and any other waiver curveball the examiners decide to throw at you.
Okay, let's get into it. The first thing you absolutely have to understand is that legal professional privilege isn't some unbreakable shield. Nope, it can be lost, and it's often lost through the actions of the very person holding it, sometimes completely by accident. The courts have a very specific way of figuring this out, and it all boils down to one central idea: inconsistency. And that's the absolute heart of it. We call it imputed waiver or implied waiver. Basically, it's something a court imposes on a party no matter what they intended to do. It doesn't matter if your client says, "But I never meant to waive privilege." The court looks at their conduct, their actions, and asks if those actions created a situation of unfairness. This right here is the bedrock. This is the High Court and Goldberg v. NG laying it all out. The entire doctrine is built on this one simple, powerful idea: fairness. The question the court is asking is, fundamentally, is it fair for one side to use part of its legal advice as a sword in the case while keeping the rest hidden behind the shield of privilege? So the crucial point is that this idea of fairness gets framed as a test of inconsistency. The High Court, in a later case called Osland, built on that Goldberg principle and gave us the modern test we use today. And this is the question you need to be asking in your exam answer. Is what the party did inconsistent with keeping that communication confidential?
So how do we actually apply this inconsistency test when we're under pressure? Well, for us here in Queensland, the go-to authority is a Court of Appeal decision called Allen. And what's brilliant about Allen is that it gives us a practical checklist and analytical framework for any waiver problem you're likely to face.
This checklist from Allen, this is your roadmap. It's gold. Let's walk through it. Number 1, it's an objective test. What they intended doesn't matter. Number 2, it's all about that inconsistency. Number 3, we're looking at the conduct of the person who holds the privilege. Number 4, context is king. Now the others deal with common situations, but look at number 7, cherry picking. This is the big one. You can't just reveal a favorable sentence from your legal advice on a topic and then hide the rest of the advice on that exact same topic. That's the core of the fairness doctrine in action, and it's a huge trap. Okay, with that framework in our back pocket, let's see how this stuff actually plays out in the real world. We're going to look at a couple of common scenarios that really shine a light on the fine distinctions you have to be able to make, especially under exam pressure. And this comparison just brilliantly illustrates the nuance, On the left, we've got Oxel tip. Here, a party put in their pleading that they believed a deed was valid. Now, that belief is about a legal conclusion, so the court said, hang on, it's unfair to make that claim while hiding the legal advice that almost certainly shaped that belief. Boom, waiver. But contrast that with Sanris on the right. In that case, the party just denied the other side's allegations about what they knew. They didn't make a positive claim about their own state of mind, and the court said, you know what, just denying an allegation isn't inconsistent with maintaining privilege. No waiver. This is such a critical distinction to get your head around. Now let's look at that cherry-picking principle in action. In Henderson v. Lowe, an expert's report quoted bits and pieces of the defendant's own privilege statement. Justice Chesterman said, "Fairness demands the plaintiff gets to see the whole thing." Why? To make sure those quotes weren't ripped out of context or being used to mislead the court. Waiving part meant waiving the whole document on that subject. But then again, look at San Etris. The court looked at a file note with some parts blacked out and decided that, on these specific facts, redacting the privilege bits didn't create any unfairness. So the big takeaway here is that partial disclosure is super risky, and whether it's a waiver always comes back to fairness in that specific context. All right, let's switch gears and talk about one of the most stressful, heart-in-your-mouth situations you can face in practice, and it's a favorite for exams. You accidentally email privileged documents to the other side. Oh boy, what happens then? The case you need to know here, inside and out, is expense reduction analysts from the High Court. So here's the story. A solicitor messed up, included privileged documents in disclosure. As soon as they realized the mistake, they were on the phone, telling the other side and demanding the documents back. The other side said, nope, too late, you've waived privilege.
This thing went all the way to the High Court, and they unanimously said privilege was not waived. And the key, the absolute deciding factor, was the immediate action to fix the mistake. That swift action showed an intention to maintain privilege that was stronger than the initial slip-up.
And the High Court didn't stop there. They used the case to remind all of us about our professional duties, which are now written down in this absolutely critical rule.
This brings us to a massive ethical point, which the High Court drove home in expense reduction analysts. Remember this number, Rule 31. Your obligations as a practitioner under Rule 31 of the Australian Solicitors' Conduct Rules could not be clearer. If you get material, and you can see it's privileged, and it's obviously been sent by mistake, you cannot use it. You must stop, you must return it or delete it, and you must notify the other side. Trying to get a sneaky advantage from someone else's mistake is a serious breach of your professional duty. Rule 31. Don't forget it.
Phew. Okay, we have covered a ton of ground. So let's boil it all down into the master points, the key takeaways you need to have locked and loaded for your exam and for your career.
All right, here is your final battle plan. 1. Always start with the inconsistency test from Osland and Goldberg. 2. Use those 8 principles from Allen to structure your answer. 3. Be so careful about pleading a client's state of mind. It's high risk. Remember Ozltip. 4. Avoid that partial disclosure, that cherry picking, because you risk losing privilege over the whole document, just like in Henderson. 5. If you make a mistake, act immediately, just like the lawyers in expense reduction. And finally, never ever forget your ethical duties under Rule 31. Get these points straight and you are going to be in a fantastic position.
So there you have it, a guide to mastering implied waiver. You see, the principles themselves are pretty clear, but applying them is all about the nuance. The real skill is developing that gut feeling, that sharp judgment to spot conduct that's inconsistent with privilege before the damage is done. Master these cases, master these principles, and you'll be ready for whatever the exam throws at you. Now, all the very best of luck.